Good evening. This is Rahul Reddy live here from Houston, Texas. Along with me is my business partner, Emily Neumann. Emily, what do you have today to discuss?
Yeah, we want to talk about how to respond to these demanding requests that FDNS is asking of H-1B employees. FDNS is the Fraud Detection National Directorate, and they are asking for more and more documents that are really irrelevant, more than what they should be asking for. So we'll talk about what are some of the things they're asking for and what you can do if you're in that situation. Also, a lot of people are asking, what are my options if I'm getting to the end of my 60-day grace period after I lost my job? I'm on H-1B. What can I do? There's a lot of misinformation out there, some bad information. So we want to go over what options you do have, what are the safest options, what are the riskier options there. We're also going to talk about advanced parole. If you use the advanced parole to travel and return back to the U.S., what are the consequences of that on your pending application for adjustment of status and your non-immigrant status? And we want to fact check this 180-day unemployment rule that people are saying is going to be approved by USCIS and coming out in 3 months. And what are they talking about, and is it really true? And more rumors we want to debunk is whether you can work if you're in the U.S. on a B1 or B2 visa. What are the limitations there? What can you do? What can't you do? And what you should stay away from. So getting back to these FDNS, it's started several years ago. Every new H-1B petition that's filed, the company pays an extra $500 to fund these fraud detection activities of USCIS. And so usually they happen after the H-1B has been approved. A few months later, they're mostly randomly selected, but a lot of times they tend to be targeted towards H-1B dependent employers. And the officers will, before COVID, they would actually come to the company's address, talk to the employer, the person who signed the petition, talk to the employee, verify that the company really does exist and that the person is doing the job they said they were doing. But then during COVID, it turned into more of they're going to reach out by email or by phone because the officers weren't traveling to do the site visits. But now we're seeing more and more of these emails asking for just ridiculous documents that have nothing to do with the H-1B petition. They ask a lot of very intimidating questions. They make it sound like you're doing something wrong so many times when all you're doing is trying to do.
They ask the questions. You have to respond by 5 p.m. today. Give us your 10 years W-2s, 10 years income tax returns. Give us all, how did you heard about this job? Show me the evidence of those things. Do we need to respond to those things?
No, none of that is required for an H-1B petition. And this whole FDNS program, the site visit program, is completely voluntary, both for the employer and the employee. Now, I understand the idea of I'm not doing anything wrong, so I should feel comfortable sharing everything. And, but a lot of times, even when you're not doing something wrong, USCIS takes it the wrong way, or they twist and manipulate it into something that you never said, to then come back and try to revoke your H-1B. So I'd be very careful about what I'm providing, only provide what's actually required by the immigration laws, and no more than that. And, if you don't want to, just tell them, hey, this is a voluntary program, I don't need to respond. And they should stop at that point. And also, you do have the option if you're the employee. Some companies, they might have you contact the company attorney that works on the company's immigration to help you with that process. But if your company doesn't do that, you can also reach out to your own lawyer and go through the email request, the document request, talk about how the response should be created, what documents you should provide, what you shouldn't provide. And the lawyer can be copied in on the response to the FDNS officer and let them know, hey, I'm represented by an attorney now, so please direct any follow-up questions to the attorney, because it can be intimidating for an employee to have to go through all of that.
I normally give an advice to the client, Emily, that if they are very nice, very good, they may want to respond to this FDNS official. But if they have been rude, you have to respond by this time, and they're going to ask many documents, many information that is completely irrelevant to the FDNS. Then I tell them my way or highway. I tell them to tell the FDNS officer, look, you're going to email me, I'm going to respond to the email. I'm not going to answer the questions, and I will decide if I want to answer the question or not. And I will normally recommend people to contact a lawyer to respond before to that thing, before you respond to the email. You have a choice. You don't have to respond. They'll say, respond to you by 5 p.m. today, by end of day today. Otherwise, they speak all kinds of words. They're very intimidating, though. And there's in the website of the FDNS, it clearly says it's voluntary. It's not mandatory that you have to cooperate with them. And if you say that I do not want to further proceed with this FDNS, they have to stop then and there itself. They do not have an option to continue if you say so. So please use your rights in these things, though. It's completely voluntary, and you're under no obligation to respond. And if you want to respond, respond on your terms. Don't respond on their terms. If they say respond to by 5 o'clock, then you can answer the question, look, I am doing a job. Okay? And the H-1B requires for me to do a job in software. That is more important, responding to you, because you put a deadline of 5 p.m. I am not going to cooperate with you. That's it. That should end. I normally give them a citation draft to them. Look, in the website of the USCIS FDNS, it says it's voluntary. I am not going to cooperate. You can send it to them. Absolutely nothing. Always you can use their own language if they're intimidating to blame them. Because you haven't been nice to me, I am not going to respond. Period. You can say that. Oh, you told me that you're going to contact me again within 1 week's time. You'll contact me after 2 weeks. I'm not going to respond to that thing. You give a deadline to me at 5 o'clock. I'm not going to respond. You are asking questions that are not relevant to the FDNS. I'm not going to respond. They should only ask about the particular position for which they are hiring, that they're inquiring about. They should be asking about the history of your entire employment history. How did you get the job? Where did you look into the advertisement? How did the interview went on? That's not the things. Whether or not you're working at the end client, whether or not that position requires a specific degree or not, those are the only things they are supposed to ask and inquire, though. So you can always request them, look, if you're going to narrow the questions, what are needed to the FDNS, I may respond to you. But if you're going to go overboard and you're going to be intimidating and you're going to tell me the deadlines, no, I'm not going to respond. So I want you to have an attitude of my way or highway. That's simple thing. When you deal with the FDNS, you deal with this simple one sentence, my way or highway. If they don't come to your way, you don't respond. If they come to your way, then at that point of time, you can consult a lawyer and then respond, though. That would be in your best interest. A lot of times we see people doing mistakes. I'm not working at my company's location. I'm violating the things. And these people go and admit them. Well, if you're working within the same MSA, the matter of solution says that you do not need any amendment. So there are a lot of defenses that are available. I don't want you to overcommit to the FDNS official. So take your time before you respond. And if you need, consult a lawyer before you respond. Don't hurry up and respond to them. And believe, just take a note of what I'm saying. My way or highway.
All right. Next, we want to talk about the H-1B and L-1 grace period of 60 days following loss of employment. 60 days really is not a lot of time, especially given how long the pipeline is for job interviews, multiple interviews, application process, and actually getting hired. And then by the time you get hired, you've got to get the LCA, notice of filing, petition prepared. So you really don't have a full 60 days in order to get that filed. So people who might be coming near the end of the 60-day grace period, if they still have not found that new job that allows them to file a transfer or a change of status, what other options might they want to consider?
Emily, one thing is that if they have an I-140 approval, though, they should seriously consider something called compelling circumstances EAD. Now, it is very underutilized at this point of time. The purpose of the government to have this is that when you are in a circumstances where you've been in this country for a long period of time, all of the time you lose the job, you have this compelling circumstances EAD, you can apply. By applying a compelling circumstances EAD, you are you are staying legally in the United States. So that means that, let's say, for example, on 55th day, if you still don't get a job, apply for compelling circumstances EAD. You and your family can stay in this country. Now, you may not be allowed to work immediately until a compelling circumstances EAD is approved, but you can stay in this country, though. That is one of the best options. But of course, if you do have a H4 EAD option, we strongly recommend that you do apply for H4 EAD. You have an H4 option, go ahead with H4 option though. Don't wait until the last day. Take a decision a little bit early, plan a little bit early, because especially for compelling circumstances EAD, you may need to do is a little bit paperwork, want to hire a lawyer. So leave it for 30 days though to work on compelling circumstances EAD. So compelling circumstances EAD, H4 plus EAD if you have that option. H4 is one other option that you can look into. Just file the H4. You can also look into the option of B2 to stay temporarily in United States before you pack and leave the country. You also can consider into a visa called F1 student visa. You can always go back to F1 visa and stay in this country. Please note that from moving from compelling circumstances EAD to H-1B is not allowed. The only thing you have to do at that point of time is that you have to apply the H-1B in the consular processing and go outside the country and get the stamping. If you already have a stamping which is valid for a long period of time, you can get the H-1B, use the old stamping, and you just have to go outside the country and come back. For B1 and B2 to H1 also, there may be some issues. From F1 to H1 also, there may be some issues. You may have to leave the country to come back on H-1B if you use those options. I want you to do a dry run, a trial run, even when you have a job, okay? You are not God, okay? Everybody, if you think so that you cannot be replaced, well, there's something wrong with you. I mean, everybody can be replaced. So have a trial run, speak with your family, speak with your friend, what are the options, what are you going to do with the car, what are you going to do with the house, how are the schools are going to be done, what are you going to do about it? Have a trial run before that layoff comes in. You will be well prepared if you do so, rather than just face the situation and try to scramble in those 60 days.
Yeah, and with that B2 option, if you do file the change of status to B2, USCIS did recently answer a question on their Twitter page where, one of the problems with B2 is the long processing times. I mean, we're still getting B2 decisions from applications we filed during COVID, during the very beginning of that. So, you file your B2 application, and then let's say 30 days later, you land that new job and you're ready to file the H-1B. Well, it can't really be filed as a transfer because you're beyond your 60-day grace period. At the same time, your B2 is not yet approved, so you're technically not yet in B2 status. But USCIS said that the new employer can file the H-1B petition they suggest in premium processing, requesting the change of status from B2 back to H-1B, even though the B2 is still pending. And they will, as a courtesy, approve the B2 change of status at the same time they approve the H-1B change of status. So you'll go from H-1B to B2 right back to H-1B, all in one adjudication. So that's good news, because prior to that, they were often sending requests for evidence asking, hey, show me the B2 approval before we can adjudicate your change of status back to H-1B. And because of those B2 processing times, you could never get the approval in time to respond to the RFE, and would end up having to consular process the H-1B. So now they've got a mechanism to be able to switch back to H-1B, even though the B2 is still pending, and they'll approve them both together if it's filed in premium processing. All right, so what about traveling on advanced parole? So you have your pending 485, you finally got your advanced parole approved since they're taking over a year now, and you decide to travel. Is there anything that happens to the pending adjustment of status because you've left and come back on advanced parole?
Nothing. Nothing is going to happen. Relax. You're fine. Absolutely not a problem. And I'm still getting questions from the people. I have an H-1B valid until 2024. This comes from Gokul Krishna. If I travel in AP, do I need to do the Margarita switch to continue on H-1B status? No, you don't have to do the Margarita switch though. You can continue. You can extend the H-1B, you can transfer the H-1B, you can move to a different H-4 EAD if you want to, even after you travel advanced parole. There are certain circumstances where, especially if you want to refile the 485, where we recommended Margarita switch, but for you to continue in H-1B, you do not need to be doing the Margarita switch. That means going out to Mexico and coming back. Also, with regards to the H4, same story. L1, same story. L2, same story. When you travel outside the country on advanced parole, when you come back, you can extend the L2, you can extend the L1, you can extend the H1B, you can extend the H4, you can transfer to a different company. You're absolutely fine, not a problem. Now, this is true only for H1, H4, L1, L2. Now, this is not true if you are on B1, B2, or if you are on F1 visa. Please consult your lawyer on that issue, though. But with regards to the H1, L1, that is true. You can continue on H1B and L2 visa. You absolutely don't have any problem. A lot of people are panicked. I want to go for stamping for H1B. I'm worried that I will be in an advanced parole. How can I want to go for stamping? The appointments are not available. Or sometimes when you go there, you may get a 221G. I strongly recommend don't go for stamping. Just use the advanced parole and come back. Your adjustment of status will continue as it is. And if you want to retain the H1B, H4, L1, L2, you're good to retain. Don't panic on that one. Now,
so
there's one thing.
If someone has the H1 and they don't have the stamp and they've got their 485 pending and they have their advanced parole, you're suggesting that they travel on the advanced parole and not worry about going for stamping, and they can still come back and continue their H1?
That is right, Emily. That is absolutely right. Why go and put my head in the lion's den and see if the lion is going to bite me or not? I don't want to. Just come back in advance parole. You're fine.
Now, what about the opposite situation where you've got your 485 pending, you've got your H-1B, and you have a valid H-1B stamp, but your AP is still pending? Can you travel while the AP is still pending if you're in H or L status and not impact your AOS?
That is right. They can travel, Emily, on H-1B, H-4, L1, L2. That will not impact the adjustment of status. However, though, the advanced parole will be denied. The reason is because you traveled outside the country while the advanced. It's not parole, it's advanced parole. Since it's advanced parole, you're supposed to get before you travel. They will deny your advanced parole. But Emily, it does not affect the adjustment of status. It only affects the advanced parole. It does not affect the adjustment of status. It will still continue. It does not affect the employment authorization. It will still continue. They will still issue. The advanced parole is where it can be denied. As soon as you come into the country, you can just apply for an advanced parole again. And as you know, Emily, filing fees is free for advanced parole.
All right.
Emily, what about these rumors that have been flying around, Emily? I mean, believe me, the Indian newspapers are going crazy. They are telling that there is 180-day unemployment allowed. If you are on H-1B and L1, you can stay in this country for 180 days unemployment. Is that true?
Completely false. It is completely fabricated, lying, utter disregard for the truth. It is not accurate at all. Do not listen to that. There is only a 60-day grace period. There are not any plans to extend that to 180 days. It's been talked about by one advisory panel, but that does not mean USCIS is going to listen to them. It doesn't mean USCIS has any plans to implement it. And even if they do, it's not something that is the law today. So only 60 days. Do not rely on having 180 days after a job loss.
We advise people to just tune into the Lawyers Network. who are practicing lawyers rather than these newspapers. I don't know where they are getting it, especially the Indian newspapers. There comes the story, there is something, and then they blow out of proportion. Now, there is another thing, Emily, that is roaming around in the Indian news channels. So, can you work on a B1, B2? The USCIS has given the permission to work on B1, B2. Is that true?
No, definitely not true. Do not do that.
Did you not read the tweet of the USCIS?
I did, and people are completely misinterpreting that tweet. USCIS said, hey, if you're in the US and you filed a change of status to B2 because you've lost your job, while you're on that B2, you can apply for new jobs, you can look for jobs, you can attend interviews while you're on B1 or B2. That does not mean that you can get the job and actually start working or work another job while you're looking for your next H-1B job. So no work is allowed on a B1, B2. That's a very strict rule. Nothing USCIS says will change that. No work is allowed on a B1 or B2.
Okay, so Emily, what if I am coming from India and I'm coming on B1, B2, B1 or B2 visa from India, and I am coming to look for jobs and attend for the interviews? That's what the USCIS website says. Okay, am I allowed to do it or not?
No.
Are
No,
you sure?
so you're right.
Did you read the tweet?
I did.
It says I can attend the interviews, I can apply for the job on the B1 and B2. And now you're telling me I can't travel from India to USA and with an intention to apply for the job, with an intention to attend the interviews. I know you told me I can't do the job, but I can't even come with the intention to apply for the jobs?
No. And that's, you have to remember that coming into the US, the immigration that you meet there at the airport is CBP. That is different from USCIS. They're under the same Department of Homeland Security, but it is a different government agency and they interpret the rules differently. So CBP has never ever come out saying that applying for jobs and attending interviews is a proper business related activity for a B1 or B2 visa. So definitely you cannot have the intention of coming to the US to look for a job, to apply for a job, or to interview for a job. When you're coming into the US, you will likely be turned back, deported, expedited removal. There are many things that can happen at the airport and have you turned around and have your visa invalidated, canceled, maybe a finding of a misrepresentation or fraud. So we do not recommend traveling to the US for those purposes.
What about if I want to apply for the visa in the Department of State saying, oh, I want to go there for applying for jobs, give me the B1, B2, the USCIS said I can do it.
Same thing. Even though USCIS says it's possible to do that, Department of State is a different government agency and they're looking at what is a valid purpose for B1 or B2. It's visitor for pleasure or visitor for business, and neither of those fall into the category of applying for jobs or attending job interviews. So no, you would likely have your visa application denied if you were to apply for that purpose.
Please, when people are taking into consideration of the tweets and all those things, you need to read the language properly though. The USCIS, what they intended at that point of time is that if you are already in USA, especially those people who lost their jobs, who have applied for the B1, B2, yes, for those, it may work that you can still look for jobs and you can attend the interviews for the job. That is true for them, but not to the people who are entering into the United States or applying for the visa. Anything else, Emily, before we go to Q&A?
Nope, I think we can move on to questions. There's one from Sue Bunker on Facebook that says there's a new bill introduced into the House, H.R. 1535, which is basically recapturing employment-based green cards, and it's introduced by both Democrat and a Republican. What are the chances of this passing and becoming law? Well, generally with immigration provisions, they're supposed to normally start in the Senate, and this one is in the House. And you know, at this point, all they're going to do is refer it to the committee. There are hundreds of immigration bills that get introduced, referred to the committee, and then they just sit there and die because they don't have enough votes to move forward with it. I don't really have any strong suggestion that this is likely to pass, even if it's a bipartisan bill. We go back to the common, you know, deadlock between Republicans and Democrats. One wants to do comprehensive reform that deals with the border, that deals with the undocumented population, that deals with all of these humanitarian issues and employment-based and family-based. And the other side wants to do more piecemeal, one thing at a time, and nobody will compromise or agree on anything. So I don't have high hopes that this will pass, unfortunately.
Yeah, this bill is introduced by Raja Krishnamurthy. Some of the times these people are addressing more to the constituents because they want to get elected, and they introduce a bill. I'm not telling that Raja Krishnamurthy doesn't have a good intention. He does have a good intention to pass the bill. I met him, I personally know him, he's a very good guy. But the chances for this bill to go through, because he's not even in the majority, the Democratic Party is not in the majority though at this point of time in the House, and in the Senate we need 60 votes. We don't know where we're going to get that 60 votes. We do have a 51 votes, but we don't know if we are going to get all the 51, plus we need extra 10 votes from the, or at least now 10 votes from the Republicans. Now, I would urge Raja Krishnamurthy and probably the administration here to actually focus on something different rather than going to the Congress, where we see everything, Eagle Act. Joe Lufgren has been trying to get these kind of things in one way or the other for decades. Nothing is getting passed. What I recommend the administration, because Raja Krishnamurthy is very close to the administration, he's in the same Democratic Party as the President of the United States. What I recommend Mr. Raja Krishnamurthy and others is to actually not count the family members, because this not counting the family members doesn't have to go through the Congress. If they do so, automatically the numbers are going to increase from 140,000 to 300,000 green cards, and that will probably clear up a lot of backlogs to a greater extent immediately in the next 5 years. Most of the people who have been applied, even those people who applied in 2021 for the green card, will be cleared up in the next 4 to 5 years. Now, for this, not counting the family members though, we don't have to go to Congress. The administration can do by themselves. We know, we've been trying to get these kind of bills passed. We wrote the letters, we contacted the congressman. Nothing is getting passed in the past 2.5 years. And this has been the same story from past 15 years, guys. You may or may not know that, but we've been in this business for a long period of time. So what my recommendation is to put the emphasis on contacting the administration and requesting them not count the family members, because out of the 140,000 green cards, only 60 to 65,000 are issued to the main applicants. Rest of the things are given to the dependents. They're already been counted towards it. Look at that. When it comes to the H-1B, do they count the H-4s? No, they don't count the H-4s. Let's not count the dependents in the employment-based immigration. We have drafted a letter. It's been provided the link, and we've been providing this link for you for a long period of time. Please use that thing. You're better off with this than going to the Congress, which we don't feel comfortable at this point of time, especially in the House, we are in the minority.
Rahul S. from YouTube posted that his perm was denied because the notice of filing contained the wrong address. The appropriate address for the certifying officer is the Office of Foreign Labor Certification at 200 Constitution Avenue. What are my options? Yeah, so the Department of Labor's Office of Foreign Labor Certification, which is the agency that approves labor certifications and reviews them, moved from Atlanta to Washington, D.C. Within the last 2 years. With that move, it required all notice of filings going forward from the date of the move to inform workers that they could contact the Department of Labor at their Washington, D.C. address if they had any information they wanted to share about the employer's labor certification practices. So unfortunately, if the notice of filing was done after the date of that move and it still has the old Atlanta address on it, there are no options. There's no likelihood that that's going to get approved if you file an appeal. So you should have your employer immediately start new prevailing wage if they don't have one valid, and then re-advertise, do the notice of filing over again with the correct address, and refile. Now, what if you're already beyond your 6-year limit or getting close to your 6-year limit and this happens? You may need to have an appeal filed of this denial in order to reach the 365-day mark that would allow you to get a 7th year extension, and then withdraw the appeal and then file the new labor certification, because you can't have both an appeal and a new labor certification pending at the same time. But you may need to file an appeal just to keep this application pending long enough so it will be pending for 365 days, which then makes you eligible for a 7th year extension of your H-1B. Once you get that H-1B extension approved and you're ready to file the new labor, you can withdraw the appeal and file the new labor, and then hope that that gets approved within that next year before you run out of H-1B time again.
Questions with regards to how long will the B1, B2 be issued? You can request only up to 6 months of B1, B2, not more than that. Sandeep is asking a question from YouTube. His wife is on H4, he's on H-1B, and his H-1B is expiring in 2025. He plans to go to India and come back and advance parole. After that, he wants to move his wife to GCEAD, but he wants to maintain the H-1B. Can he do so? Absolutely, you can do so. No problem. You can have yourself on H-1B and your wife on GCEAD. In fact, it happened with me. I was on GCEAD, I was a dependent, and my wife still continued on H-1B until her H-1B expired. So it happened with me, so it is definitely possible for you, even after a long period of time. A question from Priya that comes in from YouTube is, I have an I-140 from my previous employer. Can I use that to apply for the compelling circumstances EAD? Yes, you can. It doesn't have to be with the current company that you got laid off. You can use the previous company's I-140 approval as long as it's not been withdrawn for more than 180 days after it's been approved. You can still use it to get the compelling circumstances EAD.
Krishna says, is it mandatory for employers to offer expenses for traveling to your home country in the event that you're laid off or fired when you're on H-1B and that H-1B gets withdrawn? Yes, it is mandatory. So anytime an employer is terminating employment before the end of the validity period of the H-1B that they've sponsored you for, if you plan on exiting the U.S., the employer is required to offer to pay for your return transportation to your home country. Now, it's got to be reasonable cost, so you can't necessarily get them to pay for a first-class ticket, and they don't have to pay for dependents to travel home. But yes, they are required to offer to pay for your return transportation home. And if they don't, you can file a complaint with the Department of Labor Wage and Hour Division on the WH-4 form. And that is also one of the factors that they consider in determining whether the employer properly terminated your employment. And they can be liable to pay back wages to you if they have not properly terminated your employment. So they have to offer the return travel expenses, they have to withdraw the H-1B, and they have to notify you that you've been terminated. Those three things have to be done in order for it to be considered a valid termination that stops them from having to continue to pay your wages.
Majumdar from YouTube has this question. How do we contact administration, request them not to count the family members? The link has been provided. Whom you have to contact, their contact information is being provided in the link here. So you can contact the administration so that you don't have to count the family members.
KM says, one of my friends in India wants to come back after 10 years. Is it possible to recapture the unused days of H-1B? Yes, that is possible. So if, when you got that H-1B 10 years ago and you had that 6-year limit, if you only used 4 years, any employer could sponsor that person now to get the remaining 2 years. It has to be done for consular processing since you'll need a new visa, then apply for the visa stamp and then come in for that remainder amount of time. The other option is to go through the lottery, and if you get selected in the lottery, you get a fresh 6 years. So you only get the remainder of the time with option 1. With option 2, you get the full 6 years. But I think a lot of people are under the mistaken assumption that this only works if the H-1B was within the last 6 years. And that's because that's what the question on the form used to ask, and that's what the old instructions used to say. But that's no longer there. They eliminated that in 2017. So it could be 20 years from the time you last were in H-1B status. If you've got any time left in your 6-year limit that you didn't use, you can be sponsored for a new H-1B to get that remainder of the time.
Rajesh Gurudu has this question. He is an advanced parole. He wants to go for stamping. If he gets a 221G, can he come back and advance parole? Well, technically, you may be able to come back, but while you have in the administrative processing. But I would recommend to contact an immigration lawyer before you come back, because there may be some issues why you got issued the 221Gs. You can't just blanketly come into the United States and advance parole. So I would strongly recommend to consult an immigration lawyer. My advice in general would be that don't go for stamping, but of course people don't want to follow my directions. That's fine, but still, if you get the 221G, there are ways to come on an advance parole. Just consult an immigration lawyer before you come in.
Sai Krishna says, I had a site visit back in 2021. Why don't we see any documents from USCIS regarding site visits? And is there any reason for concern if I'm going for stamping now, if I had a site visit? Yeah, that's one of the things about this FDNS program is, after the site visit happens, no news is good news. If you never hear from them again, that should mean that everything was fine and there's nothing to worry about. But you just never know, because they don't give you any kind of document saying we've conducted a site visit and found everything was fine. And sometimes what they do with the site visit doesn't, when they do find problems, or they try to assume there's problems based on the site visit, it could be several months to years before they actually send a notice of intent to revoke on that. So I would say just because you had a site visit does not mean you should be concerned for your visa stamping. It's more about, was there anything that happened during that site visit that would be cause for concern? Was there any discrepancy? Were there any questions that were unusual? That sort of thing. Or did they ask for any documents that you provided, and those documents may show that there was some kind of problem? But there are lots of site visits that happen, and everything comes out that there's no problem with the petition and everything remains approved. That's probably the vast majority of them. But if there is a problem, that's when you'll get a notice of intent to revoke, and it could come up during visa stamping.
Rajesh has this question from Facebook. Will the USCIS deny the advance parole renewal while if I travel outside the country? Yes, they can deny the advance parole renewal if you travel while it's pending, though.
I learned from RN Law, good YouTube handle, wants to know, can a U.S. citizen who is a joint sponsor with enough income sponsor 2 different family-based immigration petitions at the same time? Yes, as long as you meet the income requirements for both. And it does typically ask, have you sponsored other family members before, and ask you to provide that information. But if you've got the income to do it, that can be done.
Emily, I want to have a follow-up question. What if the U.S. citizen doesn't have enough income to sponsor? Can he request his cousin or somebody else to co-sponsor?
Yes, so they do allow co-sponsors. So each co-sponsor has to also submit an affidavit of support and provide their tax returns and proof of their income. You can even have multiple co-sponsors if you need multiple people to meet the income requirements. But the income requirements are generally quite low. It's just a little bit above the poverty line based on the number of people in the household. And then depending on the situation, the person being sponsored, their income can count too, as long as they've derived it lawfully and they're lawfully allowed to work. They can use their own income to sponsor themselves.
Patricia has this question. I'm a green card holder planning to marry F1 visa holder. What's the process and how long it would take for my spouse to get the residency? Patricia, you can file for the green card process under the, you can file I-130 and 485 EAD in advance parole immediately, even though the priority dates are backlogged for the family-based, though. The final action dates are backlogged. The filing dates are still current. And the USCIS is accepting the filing dates. So you can file the 485 application along with I-130, 765. Now, one thing I want to note down, Patricia, is that this person whom you're marrying cannot travel until he or she gets the advance parole approved, though. They cannot travel on F1 visa stamping once you file the 485 application. It takes approximately about 2 years for them to get the green card, maybe anywhere between 4 months to about 8 months to get an EAD, maybe about 4 months to about 14 months to get an advance parole. That's a timeline that it normally takes. Question from Passikat. How long is it taking for the labor certification approval nowadays? It's EB3. He's saying it's EB3. Well, EB3 and EB2 doesn't make much difference in the labor timing, but the labor certification is taking approximately about 8 months nowadays to get it approved, though. Please take a note that this is after filing the 485 application. After filing the PERM application. It's not after the company starts the process, it's after they file the PERM application. And it takes a long time to file the PERM application. It may take almost like, there is a prevailing wage that they need to get. That's taking approximately 6 to 8 months. And after that, there is a recruitment process anywhere between 2 months to 4 months. And then they will file the PERM application. And that PERM application, once it's filed, which you said it was filed in September, is taking 8 months right now to get the PERM adjudicated.
Rohit says his wife got picked up in the H-1B lottery yesterday and wants to know if she can travel to Canada and come back without getting a stamp after receiving the I-797 approval. Depends on the timing. So number one, I'm assuming you mean after October 1st, after her change of status to H-1 has already taken effect, and she's wanting to travel to Canada and come back on H-1B without needing to get the H-1B stamp. If that's the case, yes, that can be done under the Margarita switch or automatic visa revalidation, as long as her trip to Canada is for less than 30 days. She can show her old visa stamp from her previous status, plus the I-797 approval that has an I-94 on it, and come back in H-1B status after that H-1B has taken effect in October. If she's planning to travel before October, the H-1B hasn't taken effect yet, then you need to look at what is her current status and whether she qualifies for automatic revalidation in that status, or she may have that valid visa from the current status. But she needs to be coming back in to continue that prior status, not coming back in to wait for the H-1B to take effect in October.
A question that's coming from Roy from YouTube. Can an I-140 in EB2 from company A be upgraded to EB1C while working for company B on L1A? That means that he has an EB2 approval with company A. Now he has moved out of the company. He is now working with company A on L1A. Can he move the priority date from EB2 of company A to company B's EB1C? Absolutely, you can. No problem, none whatsoever at all. Since you are already qualified for L1A, you have a good probability of getting the EB1C approval and putting the date. I would strongly recommend you do so.
Poor has a question about the A number on his I-797 approval notice. His new I-797 approval that came after his I-140 was approved doesn't show the A number above the beneficiary name. And he says, is this something I should get corrected? Looking at the application, the A number was filled out. No, you do not need to worry about correcting that. There's no requirement that you have to provide the A number when you're filing the I-129 petition. I don't even know why they ask for it on the I-129 form. It was added several years after I started practicing, because in the old days we never had an A number on the H-1B I-797 or L-1 I-797. So don't worry about it at all.
RV asked this question. I have an I-140 approval with the 2018 priority date. I moved back to India. Can I apply for tourist visa for a temporary visit? Yes, you can. However, in the DS-160 form, they will ask a question, was an immigration petition ever been filed? You need to answer yes to that question. You have an extra burden to prove that you're not going to settle in the United States because you have an I-140 approval, but normally we see mostly B2 getting approved. Be truthful. Look, I may have had an intention at that point of time, but now I'm settled in India. I don't want to go there permanently. You can do so, absolutely not a problem. We see a lot of people under your circumstances getting the B1, B2 approval.
Pakala says, can you use the 485 or 765 application to extend the validity of your driver's license, even in Texas? So Texas particularly does not like receipt notices to extend the validity of a driver's license. So your H-1B extension receipt, even though it allows you to lawfully stay and work, it doesn't allow you to drive. So you can't drive to work, even though you're allowed to work. Same thing, I've had people that even though the Texas website says they'll accept an I-485 receipt notice as proof of lawful status, a lot of times they don't. On the I-765, they need the actual EAD card. I have not had them accept the receipt for the auto extended EAD where it's expired. They usually don't, even though they're supposed to.
Pradeep has this question that if he gets laid off on 485 EAD, what are his options? Can he work in a different field in the meantime? Pradeep, there is no 60-day rule for the 485 though. If you are the main applicant, you got laid off, there are different options you need to consider. We have made a separate video on it. You may want to watch that though. The better thing is if you can find another job, definitely that's the best thing. If you can't, can you get an offer from a different company? If not, can your wife employ you, Pradeep? If she is nice to you, whether she will be willing to employ you, that's a good option too. If all other options fail, and if she even refuses to hire you, can we do one thing? We'll do self-employment. These are all the defensive strategies that may be a little bit risky, those things. Finding a job or finding a job offer from a different company would be an ideal, but if not, getting employed by the wife or some self-employment, you should consider it very seriously because we may get into trouble if they see an unemployment and there is no job offer from anywhere. They may deny the 485 outright.
Bharat says, I had 2 LCAs filed for my H1, location A in one state and location B in another state. If I work only from location B, but the company is paying my pay for location A, is there any issue for the H1? There would be an issue if the pay is less at location A. So when you have 2 locations on an LCA for an H-1B, the employer is obligated to pay the higher of the 2 prevailing wages, regardless of where you're actually working between the 2 locations. So if if the company said that they would pay $100,000 because the higher prevailing wage was $100,000, and now they're paying $90,000 because you're actually working in the other location, that's not allowed. So they definitely should be talking to an attorney to get that rectified. If they want to reduce the pay to the other location's prevailing wage, they need to file an amendment before they make that change.
Question that comes in from, can my parents come here on a B1, B2 and apply for a job? And then later on change to H-1B status. There are strategically many problems with your statements, Mr. Bhargav. One thing is that if their intention is to apply for the jobs, they cannot come here on B1, B2, irrespective of what the USCIS has said. Please disregard that, okay? The other thing is that just in case if they're already here, can they look for jobs? Yes, they can look for jobs. Then the question that you face is that can they get the H-1B? The main question for the H-1B is, hey, the H-1Bs, there are no H-1Bs available until October of 2024. So their B2 is only for 6 months, so they cannot come here and apply. Yes, they can apply for a nonprofit, a higher education institution, if that's what the intention after they come into United States. If they change their intention to apply, yes, they can do it. For a university or something like that, that is possible.
Abhijit says, can you provide guidance on how to transfer an employment-based 485 to a family-based case if the dependent is no longer maintaining their non-immigrant status but is physically in the U.S.? I think you've got two options. One would be to not do it and to instead consular process the family-based case so the individual can remain in the U.S. based on the pending employment-based 485 and wait until the I-130 gets approved and the consulate schedules the interview, and then travel to attend the interview and come back on the family-based green card. Or you have to do the transfer of underlying basis, which a lot of people are familiar with from the EB3 downgrade, upgrade to EB2 and back to EB3 and all of that. But the problem is for going from employment-based to family-based, there is no mechanism to do it. Like an employment-based, you would file the 485 Supplement J to inform USCIS that you intend to transfer the underlying basis. That does not exist for family-based. So the only way to do it is to send letters again and again and again. Or if you happen to be interviewed, you can request it at the interview. But otherwise, you usually have to seek assistance from your congressman's office because there's just no way to get that request into the right hands to actually be used.
Ramakrishna has this question, can company B file an I-140 from a different location? Do I need to work with company B to file an I-140 application? No, you don't need to be working with company B for them to file an I-140. Technically, they can still file even though you're not working for that company. Question that is coming, what is the IOE? Is there a service center? And how is that service center, is it good or bad? Well, it's technically it's called as integrated operation environment. That means it's more like a e-filing, but still you did not e-file. I know there's no e-filing for H-1B. They send it to this. There is no particular service center for it. And he's asking the question with regards to how is the approval rating for the extensions right now? They are pretty good as compared to the things what they were 2-3 years ago when Trump administration was. Definitely very, very, very good.
Talk to Sen says, will my AP be invalid if I travel out of the U.S. during the pending extension of the AP? No, if the first AP has not yet expired. So if you have a valid advance parole and 6 months before it expires, you file your extension, and you're waiting on the extension to be approved, but your prior advance parole has not yet expired, you can travel on that prior advance parole and it will not cause the new advance parole to be automatically denied because of the travel.
The follow-up question is that, do I ever need to work for company B? Well, technically it's not required. Even people can get the green card. Even you never work for company B, they filed an I-140 and they got the priority date current, they filed a 485, you get the green card. Technically, no, you don't need to. The USCIS memo clearly indicates that it's the offer of the employment, not the employment itself that is giving the green card. So let's say, for example, you're employed by Microsoft. Are you going to get the green card? No. They have to file a labor, they have to file an I-140, and then they have to get the green card. So it's not your employment, it's the offer of the permanent employment. Offer of the permanent employment. On H-1B, it's a temporary employment. On a green card, it's a permanent. An offer of a permanent employment will get you the green card. You technically don't have to work. Question that is coming, can I open an LLC on H-1B or H-4? It's a tough question to answer. If you want to be a shareholder of the company, we don't have any problem in doing so. But if you're going to be the operational person, or you're going to be managing the company, you're going to be the director of the company, you're going to sign the checks, you're going to be involved in the company management, the answer is no, no, no. Now, of course, the rule is quite different if you have an H-4 EAD that the person can open a business, can run a business, can be the president of the company, can be the CEO of the company, can sign the checks. But for the H-1B guy, no. H-4 EAD, yes.
Krishna says, can someone move from to H-4 from H-1B and then again to H-1B before the H-1 expires? So you're in H-1B, you want to switch to H-4, and then want to know if you can go back to H-1B before the H-1B expires. Yes, that is doable, and it can be done either by filing a change of status back to H-1B, or the easier way would be the margarita switch, would be to exit and come back in showing the H-1B approval that has the unexpired I-94, assuming you're coming back to work for that same employer under the same terms and conditions that you're approved for. So same job title, salary, work location, job description, all of that is the same. You can travel to Canada or Mexico and come right back to switch from H-4 to H-1B. And you could even do it after the H-1 expires, because you can recapture that unused time towards your 6-year limit. But in that situation, it has to be done as a change of status. The company, same company or new company, does have to file a petition to change your status in that situation.
Mukesh has this question. If someone has a cap exempt for I-140 approved, can they transfer to H-1B subject cap? The way I'm taking the question is that, let's say he's working for University of Texas, which is not required to go through the cap, and they can file the H-1B without subject to cap. He got an I-140 approval with University of Texas. Now he wants to move to H-1B with Microsoft. Can he do so? No. Only if you go through the lottery system, you can do the transfer to Microsoft from University of Texas. Otherwise, just because you have an I-140 approval doesn't give any preference for you to move to Microsoft. Question from Yaramsati Murali, AC21 job portability. Now, he's an EB1C, I-140 has been approved for less than 180 days, but the 485 has been filed for more than 180 days. Can he technically switch a job? Emily, I want your attention on this one, Emily. He has an I-140 approved less than 180 days. And he filed the 485 application more than 180 days. But one thing is that this is his first EB1C. Can he switch the jobs within 180 days after the I-140 has been approved? And it's been more than 180 days that the 485 has been approved. I'm thinking that maybe no, not a good idea. I'm thinking, correct me please. I'm thinking it may not be a good idea, but unless he's forced to do so. If he's forced to do so, then he should, because it's not been more than 180 days the I-140 has been approved. He does not have any other I-140. If he had a previous I-140 approval, then it's a different story, but he doesn't have a previous I-140 approval.
Well, even without the previous I-140 approval, if they withdraw within 180 days, he still gets to keep that priority date if he files a new I-140.
Right.
It's just that he can't use that I-140 for continued H-1 extensions, but he possibly wouldn't need it if he's got the 485 and he's just relying on that. So he definitely can use AC21 to switch employers, because the 485 has been pending for 180 days and the I-140 is approved, even though it's been approved for less than 180 days. But yeah, it would definitely feel better if there was an old I-140 that he could use for continued non-immigrant extensions in case something were to go wrong with that 485.
Yeah, I would recommend, Mr. Murali, that if you're forced to, definitely you don't have an option. I don't want you to give up the 485 under any circumstances. Fight for it to the end. But if you can possibly delay it, I would delay it. Possibly delay it. Now, people ask the question, when the priority date moves back, can I do the AC21? Absolutely, you can.
All right. Well, I think we're pretty much out of time for today. Thank you all for joining us. As usual, we'll be back next Tuesday at 5 o'clock Central Time to answer your questions and give you the latest updates. And don't forget, you can always subscribe to our newsletter by going to rnlawgroup.com. And if you don't follow us on Twitter, you can find us there. Our handle is @rnlawgroup, where we share lots of updates, and all of our attorneys are posting there, giving you the latest news and keeping you updated on what's going on. Thanks for joining.
Thank you very much for tuning.